Darrow was philosophically opposed, as a matter of principle, to the death penalty, that he was able to put together arguments that everyday people could understand. And one of the primary ones, and one that is utilized today frequently, is that the death penalty really isn't a deterrence. That in fact, people who commit heinous crimes, heinous murders, aren't deterred from doing it because they're worried about the death penalty. That's not really what is in their minds. And so he really, shortly after the turn of the century, wrote some famous letters and gave some famous lectures on the death penalty not being a deterrent to crime. And that's part of the modern arguments, and indeed part of the proof that's put on by people who oppose the death penalty today, that it really doesn't have a deterrent effect. That if you take the death penalty away, or you compare states that do have the death penalty with those that don't have the death penalty, that there is not a significant or marked difference in the murder rate in those communities. So he had a very profound effect.
Thank you, Harvey. Moving on. The next person I'll be interviewing is Paul Rockland, an attorney who, while working for the Physicians for Human Rights, helped write a brief to the United States Supreme Court opposing the juvenile death penalty. Unfortunately, Paul couldn't be here with us today, but we're going to interview him live from his home in Boston. Here's my first question. What is the juvenile death penalty?
The juvenile death penalty, Saul, is capital punishment, execution, for anybody who is under 18 at the time they committed the crime that they would be executed for. The United States abolished the juvenile death penalty in 2005 when the Supreme Court held that it was unconstitutional. And at that point, the United States was the only democratic country in the entire world that executed juvenile offenders.
Thanks, Paul, for that answer. So, my next question is, what is the constitutional argument against the juvenile death penalty?
Saul, the constitutional argument against the juvenile death penalty is that it violates the Eighth Amendment's prohibition of any punishment that's cruel and unusual. And up until the Supreme Court's case, Roper v. Simmons, the case where they abolished the juvenile death penalty, the court had held that the juvenile death penalty was constitutional because they said it was neither cruel nor unusual. In fact, at the time they held that the juvenile death penalty was not unconstitutional, there were somewhere around 29 states that allowed the juvenile death penalty, but very, very few states actually executed juvenile offenders. Pretty much the only state that did on a consistent basis was Texas, which executed more juvenile offenders within a 10-year period than the rest of the world combined had executed. So when the Supreme Court heard the Roper v. Simmons case that they decided in 2005, one of the things that they decided was that because a lot more states had decided that the juvenile death penalty was cruel and unusual and had abolished it, that therefore it had become that much more unusual in the United States and therefore should be abolished. They also decided that because juveniles, teenagers, have brains that are still very much developing and that they aren't able to process information the same way adults do, that they're far more impulsive than adults are, that they don't think about the long-term effects of what they do now the same way adults do, and that when they're under stress, they're likely to react very impulsively and sometimes aggressively and violently, that for all of those reasons, juvenile offenders don't have the same moral responsibility for their actions that adults do. It's not that they aren't morally responsible for what they do at all, it's just that they're not as morally responsible as adults are, and therefore they shouldn't be punished with the ultimate and irrevocable adult punishment of execution. So on that basis, because lots of states had abolished the juvenile death penalty since they had last decided the case, and because kids or teenagers don't have the same blameworthiness as adults do. They decided that it would be cruel and unusual to execute juvenile offenders, and they held it unconstitutional throughout the United States.
Thanks for that interesting answer. So, the next question is, do you think that the juvenile death penalty is cruel and unusual punishment?
I absolutely am convinced that the juvenile death penalty was cruel and unusual, and would be if it were ever reinstated, Saul. Frankly, I think execution of any human being is cruel and unusual, but it's especially so for somebody who is still a teenager and whose brain is still developing, whose emotional development is still in process, whose cognitive development is still in process, and who has an entire life ahead of him or her to learn and to develop and to grow and to reach a potential that they can't possibly know when they're 18 years old. And I think that we were lucky that there were 5 justices on the Supreme Court when they decided Roper v. Simmons, who had the wisdom to recognize that the very idea of a juvenile death penalty, that those words could be combined in a single term, is highly offensive, extremely cruel, and as unusual as any punishment could or should be.
Thanks for sharing your opinions on the juvenile death penalty. On to the last question. How are the arguments that Clarrence Darrow made in the Leopold trial different from those that would be made today?
Well, Saul, I think the arguments that Clarrence Darrow made against the juvenile death penalty were different in some ways from the arguments that have been made more recently, and similar in some ways too. But his argument primarily was that Leopold and Loeb, even though they weren't legally insane, suffered from such a severe mental illness that the judge should consider that what they called a mitigating circumstance in deciding what the sentence should be for the crime that they committed. And in the end, the judge accepted that argument, and that was the primary reason why Leopold and Loeb were sentenced to life imprisonment and were not sentenced to die. But there are 2 other arguments that Darrow made that I think resonate very strongly today, as they did many years ago. One of those arguments was simply that somebody who is still a youth, whether 18 is the borderline or not, simply shouldn't be held as responsible for their actions as an adult would be. And that's basically the argument that the Supreme Court accepted when they held that the juvenile death penalty was unconstitutional. But the second argument that Darrow made that I think is the most compelling one of all, and most powerful, was also probably the least legalistic argument. And that was that capital punishment in general, for any person who had committed a crime, really is not about punishment at all. And it isn't about deterring crimes, preventing crimes from happening. It's really about what Darrow described as a kind of bloodlust, that it's only about vengeance, that it's an action taken in anger, it's not rational, it's not civilized, and it is by no means humane. And that argument against the juvenile death penalty or the death penalty for anyone else, I think is the one that really ought to carry the day throughout the world. And in fact, it has in most democratic countries and most countries around the world. The United States lags behind that thinking.
Now I'm going to summarize what I learned during this project. I learned from the people I interviewed that Clarrence Darrow's defense of Leopold and Loeb still have relevance today. Specifically, I learned that juveniles don't have the capacity to understand the consequences of their actions. Secondly, he argued that the death penalty in general didn't deter people from committing crime. These are the very same arguments that helped persuade the U.S. Supreme Court to overturn the juvenile death penalty.